Joinder and intervention are both ways that third parties can get into a lawsuit. Joinder is done by the plaintiff or defendant himself who wishes to pull in someone else to the litigation. For example, Retail R Us sues Distribution Mania, a distribution company, for a faulty product, but Distribution Mania has an indemnity clause from its manufacturer, We Build It Corp. Indemnity basically means that We Build It will pay for all of the claims against Distribution Mania relating to the faulty product. When Retail R Us sues Distribution Mania will turn around and pull We Build It Corp into the lawsuit because they, and not Distribution Mania, will have an interest in the litigation. Intervention, on the other hand, is done by the third party itself. A third party sitting on the sidelines might realize that it has a lot at stake in a particular litigation and that its interests are not being adequately represented. It will then seek to enter the lawsuit. For example, two parties have a dispute relating to the constitutional validity or scope of a statute. The government has an interest in protecting its statutes and in the proper interpretation thereof, and may seek to intervene in the litigation to ensure that the court has the benefits of its views on what the statute actually means and why it's constitutional. Sometimes joinder is mandatory. Rule 19 says that where the court cannot possibly grant the victorious party complete relief because someone who is absent from the case, 1, has a tangible financial or legal interest in the litigation, 2, would be prejudiced by not being part of the litigation initially, or 3, could sue after the fact and gain an alternative and inconsistent judgment. If you have any one of those 3, that party must be joined into the lawsuit, unless doing so is impossible, such as because the court doesn't have personal jurisdiction or would be an improper venue with relation to that person. Or doing so would deprive the court of jurisdiction over other parties, such as by defeating subject matter jurisdiction in a diversity case. It would break complete diversity, for example. Rule 19b says that when joinder of an indispensable party is not feasible, the court will weigh various factors in deciding whether to dismiss the suit or allow it to continue without the indispensable party. Those factors are that the court will consider to decide whether or not to allow the case to continue. 1, the extent of the potential prejudice against the absent party or any of the present parties. 2, the extent to which the prejudice can be mitigated. If the court can do something to prevent the prejudice from happening, it's not going to dismiss the suit. 3, whether a judgment in the absence of that party will be adequate for the present parties. We want to make sure that those in the lawsuit will be able to get the relief that they want. And if the absent party being absent will prevent that from happening, it's a big problem. Or 4, whether dismissing the case on account of the absent party will prevent the plaintiff from getting his day in court. Sometimes dismissing the case here will prevent the plaintiff from filing anywhere, and then the plaintiff won't be able to get the relief that it requires or have it addressed by any court. Where an indispensable party cannot be brought into the suit, it is the responsibility of the parties to state why in the pleadings. They can't simply ignore the indispensable party, they have to talk about it in the pleadings. That's Rule 19. Rule 20 discusses permissive joinder. Basically, two people may join as plaintiffs if their claims arise out of the same transaction or occurrence, and common questions of law and fact will predominate over the litigation. Similarly, two people may join as defendants if the claims asserted against both of them arise out of the same transaction or occurrence, and common questions of law and facts will predominate over the litigation with regard to both. Each individual claim must be within the subject matter jurisdiction of the court. If in a diversity case, for example, the defendant tries to bring in a co-defendant, but the plaintiff's claims against the would-be co-defendant are not $75,001, or the would-be co-defendant is from the same state as the plaintiff, the defendant cannot join the co-defendant into the litigation. There's an interesting rule here with regard to supplemental jurisdiction. You might have asked why the case wouldn't be available to the plaintiff on diversity jurisdiction using supplemental jurisdiction. You might have thought we would be able to bring third parties into the litigation via supplemental jurisdiction. But plaintiffs in diversity cases typically may not use supplemental jurisdiction to bring in non-diverse defendants. Similarly, if for some reason the defendant wants to bring in a co-defendant, as in our example, you generally cannot use supplemental jurisdiction to bring in a new defendant. Supplemental jurisdiction is available to defendants to bring in a new plaintiff, and to everyone in arising under cases. Again, this restriction only applies in diversity cases. It's pretty nitty-gritty, and I would imagine most professors won't care very much about it for the purposes of your class. That was Rule 20. Joinder under Rule 14 is quite different. It says that the defendant can bring in a third party as its defendant. And parenthetically, this is sometimes called impleader. Don't confuse impleader with interpleader, which we're going to discuss later. Impleader is a type of joinder defined by Rule 14. Impleader is something completely different. Don't allow yourself to be confused. The defendant actor acting under Rule 14 is known as the third-party plaintiff. He's going to function as a plaintiff against the new defendant. In our previous hypo, this is Retail R Us, Distribution Mania, and We Built It Corp. Distribution Mania is the defendant as against Retail R Us, but as a plaintiff, or more accurately a third-party plaintiff, against We Built It Corp. Rule 14 says that the third-party plaintiff must file a complaint and a summons against the third-party defendant, just as if the third-party plaintiff were a true plaintiff. That is, the defendant must file a complaint and a summons against the new defendant, the third-party defendant. To take advantage of Rule 14, the defendant must file its complaint within 14 days of filing its answer against the original plaintiff, or with permission of the court thereafter. The third-party defendant functions typically as any other defendant would, but there are two big exceptions in which the third-party defendant does not act like a typical defendant. First, the third-party defendant can make some claims that a regular defendant could not. Second, we ignore the third-party defendant when assessing some of the rules relating to jurisdiction. We'll go over both of those. First, the third-party defendant has the right to raise claims against the original plaintiff that a normal defendant typically would not be able to raise. The general rule is that a person cannot raise someone else's claims. If you have a contract dispute, I can't serve as a plaintiff against the would-be defendant on your behalf. You have to raise the claim yourself. But the third-party defendant can stand in the shoes of the defendant to make claims against the plaintiff. Let's say that the contract between Retail R Us and Distribution Mania was drawn up on the back of a napkin, and it just makes no sense. By hypothesis, there's no contract. If there is no contract, then Retail R Us can't sue on a breach of contract theory. But Distribution Mania, the third party that has no interest in the case because it has an indemnification clause, doesn't bother to raise that defense. After all, it doesn't really care about the case that much. We Built It Corp inherits all of the affirmative defenses that once belonged to Distribution Mania, even though they've been waived. Remember, Distribution Mania has already filed its answer, and it waived it by failing to raise that affirmative defense. Nevertheless, We Built It Corp can raise that defense in its answer. It can argue that the contract between Retail R Us and Distribution Mania was void. Second, the other exception to the general rule regarding third-party defendants, we ignore third-party defendants when assessing some of the rules relating to jurisdiction, and I'll give you two examples. One, the third-party defendant cannot destroy diversity. Note that this is different from typical joinder under Rules 19 and 20. So if Retail R Us and We Built It Corp are incorporated in the same state and are thus not diverse parties, the defendant, that is the third-party plaintiff, can nevertheless bring in the third-party defendant using supplemental jurisdiction. Again, supplemental jurisdiction is going to be available here. We're not trying to bring in a new plaintiff. We're bringing in the third-party defendant. The fact that the third-party defendant is not completely diverse from the defendant, or perhaps from the plaintiff himself, it doesn't really matter. It's not going to destroy diversity jurisdiction. Number two, we do not take the third-party defendant into account when assessing venue. There are some other rules here relating to jurisdiction which really get nitty-gritty, and I'm going to assume that your professor is not going to get into them, but if they do, be sure to listen up because we're not going through all of them now. We're going to discuss counterclaims in a moment. For now, a counterclaim is a claim that the defendant makes against the plaintiff. Essentially, for the purposes of a counterclaim, the plaintiff becomes a defendant, and the defendant becomes a plaintiff. Now, Rule 14 can make litigation very messy. It also gives law professors a lot of fun. We'll discuss a couple examples, and the point I want to make is to show how litigation can just grow out of control using Rule 14. If a defendant makes a counterclaim against the plaintiff becomes a defendant, and can now use Rule 14 as if he were a defendant. That means that the plaintiff can now bring in a third-party defendant. Now, the plaintiff is going to be acting against a defendant, and against the third-party defendant directly, but the third-party defendant has all of the rules of a third-party defendant, not a defendant. Makes things rather tricky. Any third-party defendant, whether brought in by the plaintiff or by the defendant, can add his own parties using Rule 20, Rule 19, or Rule 14. So the third party defendant can bring in plenty of new parties. A typical litigation, Party A versus Party B, using the rules of joinder, particularly Rule 14, and Rule 19 and 20 as well, can transfer A versus B into something that's a complete mess, and law professors like to give you messes on your law school exams. It might be difficult even to know who the plaintiff and who the defendant are once you're all done with the facts. If you get a question like this, obviously we can't go through every example. They get very complicated. You really need to see them on paper, and that's my recommendation. Draw it out. Read the question very slowly. Don't rush through it because you're going to get it wrong if you do. I know there's a time pressure, but this is the only way to get the question right. Read through it very slowly. Draw a map. Make sure you identify the plaintiff and the defendant, because those are very important parties. And when you bring in new parties through joinder, particularly through Rule 14, identify so on your paper. If you have a third-party defendant, be sure to mark the third-party defendant, because the rules might be different with relation to that third-party defendant vis-a-vis the other parties. Rules 14 and 20 are there precisely because we want to give the parties a lot of power to structure the litigation, sometimes even taking the litigation out of the hands of the plaintiff, typically the master of the litigation. Why do we do this? It's to ensure that as many claims relating to the transaction at issue are litigated at once. Judicial efficiency. Better to have a very complicated proceeding than to have many different courts assessing the same facts and the same questions all over the country. There's one more rule that you need to know regarding joinder. Rule 21 says that if an improper party was joined in the action, any party can ask that improperly joined party to be dismissed. Rule 21 also says that a court can dismiss an improperly joined party on its own, even without request from one of the parties. The court has authority to dismiss an improperly joined party at any time in the litigation. So if the parties go too far in bringing in a whole bunch of unnecessary parties and make things unduly complicated beyond what the court should have to address in a single litigation, the court can take care of that itself. And that should answer some of your questions about why we allow these very permissive rules relating to joinder. Finally, intervention. Rule 24. It allows third parties to intervene in a pending lawsuit on their own, without an existing party bringing them in. 24A provides for intervention as a matter of right by virtue of the intervener, the proposed new party, having 1, a direct, substantial, and legally cognizable interest in the suit. 2, interest that may be impaired by not allowing him to intervene, such as through a collateral estoppel, res judicata, or other means. And 3, and you need all 3, that his interest is not being adequately represented by the parties, perhaps because the interests of the litigants do not align with the interests of the intervener. Again, the potential intervening party who wants to intervene by right under 24A has to have a direct, substantial, and legally cognizable interests, that his interests may be impaired by not allowing him to intervene, and that his interests are not being adequately represented in the lawsuit because some of the parties have differing interests. If the intervener can show all 3, he's in. The court and no party can keep him out. Rule 24B allows for discretionary intervention for people who have a claim or defense that shares common questions of law or fact, if allowing the intervention will not unduly delay the litigation or prejudice the original parties. Again, the standard is a common question of law or fact. If you have that, even if you don't meet the 3-part test that we had for 24A, you can get in, but it's discretionary. And the big question we're going to be looking at is whether the intervention will unduly delay the litigation or prejudice another party.